My name is Joellen Meckley. I am the Managing Director of the American College Center for Special Needs. And I am joined today with Tom Brinker, who is an adjunct professor of taxation and the chair of special needs planning at the American College of Financial Services, as well as being the program director of our chartered special needs consultant designation. We're going to be talking about Special Needs Planning 101, Critical Insights for Every Practitioner. Today's presentation is meant to be an intro level overview of the most critical aspects of special needs planning that any practitioner really should have a basic understanding of, and is also of benefit to others who are either caregivers for those living with disability or other support professionals, et cetera, who work with individuals living with disability. Before we get started, I'd like to announce that we do, in case you hadn't already heard, we have another a portion of our virtual advanced special needs planning symposium this year. This is our first version, or our first program, Special Needs Planning 101, an introductory level. And then we're going to have 3 more advanced level sessions on November 5th from 12 to 3. We're going to have 3 different, this will be 3 CE credits available on November 5th. The same place where you went to sign up for this, you can also go and sign up there for the November 5th sessions. It's going to be hosted on the college's Knowledge Hub Plus platform. You do need to register for Knowledge Hub Plus in order to be able to view those. But this is going to be a fantastic program. We have a financial planner and expert attorney talking about issues related to divorce for special needs families. We have a team of legislation and policy experts from the Special Needs Alliance who are going to be doing an update on recent legislation that impacts those who are working with individuals with disability. And then finally, we're going to have a session on how do you correct, kind of complicated problems in someone's estate plan after they have passed away that can potentially disrupt someone who has special needs benefits. So it's going to be a great show with some really valuable education being shared. During our presentation today, we have a lot. Tom and I have packed a lot of knowledge into this, and I don't think we're going to have the chance to stop and answer questions during it. However, you'll see at the bottom of your screen, there is a Q&A box that you can click, and it will enter a question or comment into the chat. And what Tom and I have agreed to do is have each other's backs. And while I am speaking, he's going to keep an eye on the Q&A and try to answer live, and vice versa for me when he is speaking. And then we have hopefully left some time at the end for additional questions. And again, it's I understand that because we are touching at a very surface level on a lot of these issues, inevitably people are going to come up with great questions because we're not exhaustively covering every single topic. A lot of the topics that we're covering today could basically be their own 1 hour long or day long seminar. So, all right, so we're going to start out with just a quick description of the American College Center for Special Needs, in case you haven't heard of it. So that is the Center of Excellence that I oversee at the American College. We have several centers of excellence focused on either different critical subject matters for financial advisors or that represent different populations within the professional setting. And at the Center for Special Needs, specifically, our mission is to elevate the knowledge of financial service professionals serving those caring for others with special needs through an ongoing comprehensive lifetime planning process. We do that through offering the Chartered Special Needs Consultant Designation Program for financial services professionals. But the program, again, is open really to anyone. If they want to enroll at the college and take the 3 courses, which are college level courses, you are welcome to join us. You do need to meet certain criteria if you want to use that designation. And at the end of the presentation, if we have time, Tom's going to talk a little bit about that. The vision for the American College Center for Special Needs is to be the nation's leading voice on financial planning for professionals supporting special needs families. Our center is the only one like it within an academic setting in the country, and our designation is the only designation that applies specifically to clients who are living with disability or special needs. So we're very proud of what the college is doing in that regard. All right, so we're going to kick it off by talking about the importance of special needs planning and why it matters for financial professionals. As I said at the outset, where we came up with the concept of doing a special needs 101 session is because not every financial advisor needs or financial planner or financial services professional of any type needs to have an exhaustive understanding of special needs planning. However, and I come to this as from a lawyer's perspective, we use the term issue spot all the time in the practice of law. And that is you just need to know to recognize when are the situations where you need to say, hey, I think there is an issue here. I need to get some extra help from someone who is an expert. So that's the goal of today's presentation. So the other reason that we want to talk about the importance of special needs planning is because of the unexpectedly high rates of disability that we have in this country. Now, obviously, there has been a lot of talk in the news lately about autism spectrum disorders. So we shared some of the actual rates. It is a major issue here in this country. Children have been diagnosed at an increasing rate over the last several years. You can, again, read through some of these statistics on your own. But even beyond autism spectrum disorders, about 1 in 6 of all children ages 3 to 17 have been diagnosed with a developmental disability, autism, blindness, ADHD, cerebral palsy, etc., genetic disorders, with almost 1 in 5 nationwide of all of us having a disability. So again, 20% of the population is a big chunk of the population. And why does this matter? And we put increased care costs, but it's beyond just increased care costs. It is increased life costs, which involves care, obviously, if you are someone who is living with a disability. Life is more complicated. Not only do you need have extra medical expenses, et cetera, but cost of living, modifications to the home, different types of transportation, special therapies, special education, medical devices, all sorts of things, caregiving support, sometimes paid caregivers, et cetera. So as our rates grow up and do continue to rise, obviously being able to ensure that those clients are financially secure is absolutely essential. All right, the next thing we're going to talk about is the caregiving experience and what is the advisor's role in special needs planning. Again, why this is a critical thing to think about is because even if you've been a financial advisor who has many, many, many years of experience, you're going to find that if you're working with someone, a family that is dealing with a child with special needs, an adult who has become unexpectedly disabled later in life, the stresses and strains that they are dealing with in their life are very, very different from what your average client is dealing with. So we want to talk a little bit about how to be sensitive to that. So, what is the reality of caregiving? The high rates of anxiety, depression, burnout, those things I think we all understand that when you are a full-time caregiver, it can be extreme. There can be moments that are really, really extreme, and caregiver burnout is a real thing. Many times parents are grieving the loss of a typical life plan for their loved one, or this could be a spouse with a husband or a wife who has become unexpectedly disabled. And there is often isolation due to there being a lack of understanding among friends and family. So significant emotional strain. There's also financial pressure. Many caregivers end up being forced to work reduced hours or leave the workforce entirely. So you can imagine the secondary, tertiary effects that can have, for example, on someone's own retirement planning because they have become focused on their caregiving needs when they're younger. There are out-of-pocket expenses for therapies, home modifications, transportation, things that are not all covered by health insurance. There is a tremendous amount of financial impact. And then there's logistical challenges that can be overwhelming. These individuals are coordinating medical appointments, education services, daily care. They are navigating what you're going to hear about is a very complex benefit system that has extensive documentation requirements. Special needs parents or other caregivers of, say, adult disabled individuals are acting as a case manager, an advocate, a gatekeeper, a caregiver, hands-on caregiver all at once. So that is the reality of caregiving. So what do caregivers need but rarely ask for? And again, if you are have a loved one with a disability or a special needs parent, you are probably used to surviving and figuring out a lot on your own. And that's understandable because there is a significant lack of accessible, informed financial guidance out there that is tailored specifically for disability needs. You probably understand that there is constant vigilance. You're always worrying about emergencies, service gaps, and in the case of a parent with a child with disabilities, you are very, very much so often worrying about the future. There's an emotional toll that comes along with that. Really, because you're trying to balance advocacy in the present term with the thinking about the future as well and the long-term planning. And you can get so caught up in the present that you lose sight, understandably, of the future. So that's how professional advisors can really help. They should be the person who can take some of that burden from you, help you walk through the future plans for your loved one and for yourself at the same time, and can help coordinate financial strategies, legal and care planning strategies, can give you clarification as to how benefits work, et cetera. And as an advisor, your role is basically to simplify that complexity. That should be your main goal. You should be able to anticipate your client's needs and reduce their cognitive load, reduce their mental load, and additionally be as flexible as you can with that planning so that you can adapt to the circumstances that are inevitably evolving at a fast rate with a client with disabilities. So what do I like to say? What is the advisor's role? Just be human first. Um, Seems like that shouldn't be that much to ask for, but try to approach every financial conversation with empathy. Understand that the long-term goals are deeply emotional and personal in situations like this. Another huge role for the advisor is to become a connector. We're going to talk about that at the very, very end, but you can be the hub source of information. You don't have to have every answer. You just need to know who to call to help your client or who to refer them to. So that could be referring to special needs attorneys, case managers, benefits advocates, et cetera, or being able to point them in the right direction for educational resources in the community. And also, you want to tailor the planning process. Simplify information without being condescending. Prioritize that flexibility because there are usually unexpected turns in this situation. And wherever possible, simple suggestions like using visual aids and clear documentation, again, to reduce the overwhelming aspects of it. And my pro tip for the day is always ask yourself in this type of engagement, what would peace of mind look like to you if you were sitting in your client's chair? So, creating a lifetime plan. So, we debated over whether to put this at the beginning of the presentation or the end of the presentation. And we ended up deciding that we want to put the lifetime plan at the outset of the presentation so that you give that high level understanding at the outset of what are the sort of things that go into someone's lifetime plan in a special needs planning situation. So, what are the initial planning considerations? This is not that different from your typical financial planning engagement, right? You're going to be gathering at the initial outset, you meet your client. You're going to be gathering, organizing, and communicating with that client to identify what is their life situation, what are their goals, what are their needs. But then you need to focus in and understand the unique financial and emotional situations of those families caring for individuals with special needs. You're going to be having some difficult conversations with them that you might not be having with every single client that you have. And you need to get comfortable feeling uncomfortable sometimes. You're going to need to establish and address both short-term as well as more comprehensive life goals. Again, that's common to any sort of planning engagement. You need to understand the basics of your financial statements, et cetera. But really, one of the most important things of the special needs engagement is ongoing communication and listening. That is at the heart of special needs planning because you need to come back over and over and over again and revisit those plans and update those plans. So how I like to explain what is a life plan to a client, just as this is verbiage that you can file away and use if it helps to explain it to your client. So developing a life plan is an ongoing process. It involves articulating goals in the major areas of life and then developing a plan so those goals will be achieved. This involves helping your child develop the skills needed to carry on after you're gone and establishing a support system that will enable your child to live a happy and rewarding life. That is the value proposition with doing a truly comprehensive life plan. All right, so next we're going to talk about the legal and financial stages of a special needs planning case. And we've taken this from two different viewpoints. First, we're looking at what are the two critical stages from a legal and financial perspective. And then we're going to take it from the perspective of the caregiver. And this is, I should say, this applies, again, thinking primarily about folks, parents who have a child with special needs. So primarily from a legal and financial perspective, your two biggest touch points are going to be looking at, pre-age 18 and then from age 18 and up. That is when the rules change, so to speak. So under age 18, parents have a support obligation. This can negatively impact public benefits eligibility because parents are the natural guardians and sole decision makers, and how it can impact public benefits eligibility. When your child is under your care and control under the age of 18, if you're applying for public benefits that are needs based, we're going to talk about that later some more, meaning there are income and asset caps that you have to meet if you're going to be eligible for those benefits. Under the age of 18, they're not looking just at the child, they're looking at the child and the parents as a cohesive unit. So many times there are families out there where up until the age of 18, their child is not eligible for SSI, is not eligible for Medicaid or other means tested, income asset tested public benefits. But then in stage two, which is age 18 and up through the rest of their lives from a legal and financial perspective, those deeming rules no longer apply. This impacts public benefits eligibility in a good way. You could have parents who are relatively affluent. However, in light of the fact that their child has a permanent lifelong disability after the age of 18, that child can become eligible for many, many state and federally supported programs. And additionally, at age 18, depending on the child's decision-making capacity, legal guardianship might be necessary. We're going to talk about that again in more detail later on. And the reason for that is because if that individual truly, and this is true of any age, loses decision-making capacity, cannot make legal or financial or medical decisions on their own, there is going to need to be some sort of supportive arrangement put in place. All right, so there's 4 stages, this slide and the next, that we're going to talk about from a non-legal, non-financial perspective. So your first stage is under the age of 3. This is where detection and early intervention with respect to the disability is really, really critical. Parents might want to select an advocate or a special needs lawyer at this stage to determine the appropriate therapy and education. And this is true, again, regardless of finances, et cetera. This applies to everyone. Then the second stage is really ages 3 to 15. This is when they are starting to enter the public school system. So you're going to be thinking about whether or not an individualized education program or an IEP is appropriate for that child with special needs. And in some cases, you might need an advocate or a special needs lawyer to obtain the special education that you have the right to obtain. If the public school system is unable to comply, sometimes there are special schools that can be required that are available and can deliver the appropriate level of education with the public school system basically paying for that education. Children with disabilities, significant disabilities, are entitled by law, federal law, to receive a public school education. But again, we know the reality of some of our public schools, they just can't meet their needs. So, and sadly, sometimes there are parents, many times I should say, need to fight for these rights. So then stage 3, we're looking at age 16 to 21. So just like children really of any in any situation are getting ready to launch at this age. And in many ways, it is no different than those individuals living with disability. So from age 16 to 21, they're entering high school. Many individuals with disability are able to hold down a job. Sometimes it is a very modest job, but it's a fantastic addition to their life. It's not necessarily to support themselves, but is to teach them independent living skills. And ages 16 to 21 is when you want to start training and rehearsing for daily life skills, and in some cases, the possibility for independent living. It's not going to happen overnight. It's going to take years. So as a parent, as a caregiver, you need to be thinking about that then. And then we have stage 4, which is age 22 and up. And why I say age 22 instead of 18 is because the federal right to a public school education for an individual who is disabled is up to the age of 22, meaning they can continue going to public school till the age of 22. And this can be a godsend for a lot of parents because they are counting on being able to work during school hours, et cetera. That they drop off a cliff at age 22, to be perfectly frank with you. And if your loved one is someone who needs significant care, significant support, that's when you're going to be looking at other state level services like therapy, vocational training, residential living options, daycare programs, et cetera. And you also want to start planning for your child's needs for after you're gone. This is not a pleasant topic that parents want to start thinking about, but logistics such as housing, which we're going to get into, and other aspects of planning don't happen overnight. You're better to start many, many years before you are anticipating being gone, or many years before you are anticipating your child moving out on their own or living in a different setting. So, what are really the key components of what we call a life plan in the special needs planning world? So, housing and residential care alternatives, which I'm going to dive into next because these are often the most challenging issue. At our annual in person special needs planning symposium, when I get feedback from the attendees, what they've said each time is that housing is the most difficult problem for them to help solve for their clients. So, we're going to dig into that a little bit. Educational opportunities, potential employment options, social and recreational activities, mental health resources, advocacy, care coordination, and thinking about who would be appropriate to serve as a guardian or a trustee. Again, once you, the parent, are out of, are no longer able to help your child. So let's dig into the family living options. So some of these are going to feel like common sense, which is number one, a family living arrangement. Your child is home with you, or your client's child is home with you. And this also can extend to after parents pass away. I can't tell you when I was practicing and seeing clients as a special needs planning and elder law attorney, the number of people who were aging at home together with their adult disabled child. Um, uh, Life expectancy is increasing for all of us, and the same is true for uh, young people who have had a developmental disability. The family living arrangement is more and more common, and it is possible that, another family member may be willing and able to take over after you're gone. If not, another option is there are adult foster care programs. And I should also say at the outset, with these other options that we're giving, I don't want to mislead you and think that there is just this huge range of available openings that you can just do a quick Google search and find a foster care in your area. It is easier said than done, but these are the sorts of things you want to start researching. So this is, again, it's a family living arrangement, but the caregiver is not a family member. It is foster care, just like think of the child, a child's foster care situation. Group homes. These are residential houses that house several unrelated individuals with disabilities. They could be public or privately owned. Ideally, your loved one would enter that group home before the death of both parents. So again, I talk about living arrangement number one, where the parents are the primary caregivers well into later life. Their adult child may be 50 years old, 60 years old, older when their parent finally passes away. That is a very difficult point at which for that individual for the first time ever to think about living outside of their family home. So ideally, they would enter into this alternative living arrangement while mom and dad are still alive. So mom and dad can help them make that transition, can visit with them, can reassure them that everything is okay. And the biggest takeaway, there tend to be, for the best group homes, there tend to be waiting lists. For any group home, there tends to be waiting lists. So it's something to bear in mind. So a community residential setting, this is again typically less severe disabilities, and care can be provided by a house manager or rotating staff. So here is where we are working our way up to individuals who are living more and more independently, or capable of living more and more independently. The next stage would be an intermediate care facility. So this is sometimes large complexes of buildings or smaller community residences that again are designed for moderate to severe disabilities, then working our way up to independent supported living. So this is really designed for those who need truly limited supervision. They might be living alone or with roommates in a house or apartment. And again, we encourage in that situation the family member, friends, and others visit regularly for support. Sometimes for parents of special needs, children, it's difficult for them to imagine their child being in this situation or in this type of setting. But I have had incredible success stories, and it's really, really heartwarming. And again, in your area, there's tremendous variation as to what is available around the country. There are some places, Massachusetts comes to mind, Cape Cod, California, other places where there are almost like pilot programs out there with housing for those living with disability and special needs that are doing really, really creative and interesting things. So start the research early. That's all I can say. And reach out to a chartered special needs consultant or a special needs planning attorney for help. And then last, we have the other living arrangement, which is, something that most people don't want to, or I should say most loved ones don't want to think about their loved one being in. And this is really institutional care. It is less, it used to be that anyone with any kind of disability ended up in a state home, sometimes at a very, very young age. Parents were discouraged from keeping their children at home. That has completely made a 180. over the last, let's say, 30 years, where we're looking at deinstitutionalization. However, the difficult reality of many of these situations is that there are sometimes individuals living with disabilities who have medical needs that are so significant, and their care needs, or physical care needs, are so heavy that it can be the only and really best option for them. So an institutional setting is going to have custodial care, meaning personal care, et cetera. They're going to be regularly evaluated by medical professionals. They'll have nurses, doctors who are coming in there to check on them, and treatment and additionally training available on site. So where are some informational sources that you can go to for these living arrangements? Your local school, believe it or not. Hopefully you have a SPEAC, special needs educational access committee, and they're going to be bringing in resources that you can learn more about options. Whatever is your district agency, your state agency serving individuals with special needs, they're going to be able to provide you with a list of the resources that are available in your state. Exceptional Parent Magazine. If you haven't subscribed to this or found them online, I highly, highly encourage you. It is a fantastic publication that is really designed to serve a very niche purpose in terms of the publications world, and it is a tremendous resource. Groups like the ARC and NAMI, if you've not already affiliated with an organization like that in your state, you want to look into that. And again, organizations like the National Council on Disability are all great resources for living arrangements. And the last component, which in some ways is one of the most critical components, and this is the letter of intent. And that is because a lot of the things that we've discussed today, like where your child lives, et cetera, whether they have a part-time job, what their preferences are, none of these can be forced. In your will, for example, you can't say, when I pass away, my child must live here. That is not something that you can control after you're gone. So it's really, really critical to have what we call a letter of intent, which takes everything we've just discussed and reduces into writing the goals and information that are contained in that life plan. And it is a roadmap for future caregivers. It's going to cover all of those topics in detail. And hopefully is also going to build in, really critical guidance about your loved one's preferences. They love to watch this TV show every Thursday night at 8 p.m., although I know we don't have, shows like that anymore that show up once a week at a specific time. But simple preferences. They love this flavor of ice cream. You can't do enough in terms of, just in case your loved one ends up living in a situation where they are not with people who have known them their entire life. And you want to make sure you review that letter of intent at the very least annually. All right, next, we are going to turn it over to Tom Brinker, who's going to talk about some critical tax planning considerations.
Joellen, thank you all. First of all, thank you all for attending today. I know a lot of you have been on the edge of your seat waiting for the tax planning considerations, but this is not really a primary importance for our clientele, our families. It's clearly important, but remember, this needs to work in conjunction with all of the other planning you're going to be doing for your clients. As we'll see shortly, the old adage was, well, if I have a special needs trust, I've completed all of my planning. No, you have just begun. So understanding the tax landscape for families with disabilities. Now, we often know that we cannot be planning in isolation. So we have to be aware of not only the special needs planning landscape, but what are the tax implications of our plan? Some basic issues. When you look at your child, son, daughter, who is now, let's say, over the age of 23, can I still claim that individual as a dependent? Of course you can. There is no age limit for a child who is totally and permanently disabled. Why is that important? Well, there's a $500 other credit you may be entitled to. What expenses are deductible to qualify for these credits? We'll talk about in a moment. How are special needs trust even taxed? And we must make sure that we align all of our different forms of counseling and advice so we put forth the best possible plan. So a lot of us, again, secondarily, we look at these tax benefits as clearly being of secondary or not as important as the primary benefits. But clearly, we want to make sure we pick up on any and all potential tax benefits and deductions or credits for our dependents. We look at medical expenses, special schooling, which is an incredibly large out-of-pocket cost, impairment-related work expenses. They work on the income tax side, but they also work in reducing our countable income, substantial gainful activity, be it for SSI or SSDI. The child and dependent care credit. We know statistically, historically, that would apply to people under the age of 13. Well, again, it also applies to individuals who are totally and permanently disabled. Adoption cost. One Big Beautiful Bill Act said now up to $5,000 of that credit is immediately refundable. So look at our formula for a second. And this formula has not changed since 2018. We look at income in the broadest of senses. Well, that's economic income. And economic income includes quite a bit of income that is simply not subjected to income tax, like the death benefit on a life insurance policy, interest income on municipal bonds, gifts, inheritances. So we look at economic income, and from that we subtract these exclusions, items that are simply not subjected to tax. The starting point in preparing your tax return is gross income. Page 1 of your Form 1040. Then we have our deductions for AGI, reducing our gross income. That yields AGI. And AGI is critical. Why? AGI is the gatekeeper. See, AGI determines a plethora of opportunities for us to claim as deductions or credits on our tax returns. And we know the higher your AGI, the less likely you can claim many of these touted benefits we have. Well, you'll notice from your AGI, you subtract the greater of your itemized deductions or your standard deduction. Now, the standard deduction is based upon your filing status, and it's pretty high right now. For 2025, for example, it is $31,500 for a married couple filing jointly. Half of that if you're single or married filing separately, $23,625 for that single parent household. With the standard deduction being so high, how many people actually itemize? Well, I saw over the weekend that it's only 10% right now. Will that increase? Highly unlikely, but for our families, it's higher than 10%. You'll notice here too, there's no deduction anymore for exemptions, be it personal or dependency exemptions. So from your AGI, you subtract the greater of your itemized deductions or your standard deduction, and that yields taxable income. We determine our tax. We compare it to the tax withheld, our credits, our estimated tax payments. Either we owe additional money or our government owes us money. So how do we reduce our tax burden? Well, clearly, if you followed the One Big Beautiful Bill Act, you would say, wow, I can deduct now up to $40,000 in state and local income taxes, real estate taxes, personal property taxes. But there's a caveat. Your AGI needs to be below $500,000. So in this case, you would need to focus on keeping your AGI below that $500,000. When you look at your medical expense deduction, if you're planning on itemizing, keep in mind you have to exceed $31,500. And even if you itemize your unreimbursed medical expenses, and that could include special schooling, it can include medical conferences and seminars, it can include home improvements for your child, your sibling that has special needs, an elderly parent, but they collectively need to exceed 7.5% of AGI. Medical expenses apply not only to you or your spouse, but also your children. Again, even if you exceed that 7.5% of AGI, let's say hypothetically your AGI is $100,000. Step one is, in order to have $1 of a deductible medical expense, you would need $7,501 to get $1. When you add this with the other itemized deductions, collectively, they still need to exceed your standard deduction. The child and dependent care credit. Now that has been greatly expanded for 2026. The credit is typically 20% if your AGI exceeds $43,000 in 2025. And the earned income credit, well, that really applies to those caregivers, maybe ourselves, who do not have a lot of income, be it earned income or AGI. So what are some of the eligible medical expenses? And this is a big ticket item and often overlooked. People simply assume we're claiming the standard deduction. Well, under Section 213 of the Internal Revenue Code, medical expenses include any amount paid for diagnosis, cure, mitigation, treatment, or prevention of disease, or for the purpose of affecting any structure or function of the body, and transportation at 21 cents per mile, primarily for and essential to the above medical care. Also, parking fees. Transportation can involve air travel, train travel, bus travel. Now, there are significantly overlooked medical expense deductions. And when CPAs are putting out their tax return organizers, they don't go into a lot of detail as to what is deductible in this arena. But we have capital expenditures for medical care, which is often overlooked. Special schools and institutions, not as much today. Why? It's such a big ticket item. Medical conferences and seminars, if recommended by your physician. Now, you're not allowed a deduction for everything. Illegal operations or treatment. Well, the real question is who's involved with these? But it's at the federal level. So even though something may be state legal, if it's not federally legal, it's not going to be a valid medical expense deduction. Cosmetic surgery. I know you're thinking Botox. That is not tax deductible. Now, reconstructive surgery is for deformities. You're involved in an automobile accident. That is different. Disfigurements arising from trauma or disease. Trips to improve general health, not tax deductible. Non-prescribed medicines, drugs, vitamins, and health foods. But if you look at that last line, non-prescribed medicines, drugs, vitamins, health foods, they may all be tax deductible if you have an organized, prescribed plan that your physician has substantiated. So get your doctor on board here. So an item that is typically missed, and this is a humongous opportunity. Capital cost home improvements incurred for medical reasons. Permanent improvements in the taxpayer's residence or office are deductible as a medical expense if recommended or prescribed by a physician for medical reasons. So what can we deduct? And this is kind of a crazy deduction. The feds want to know, well, what did you expend? Did it increase the fair market value of your home? Well, if you spend $100,000 on an improvement for your child with a disability and your home increases in value by $5,000, you can deduct $95,000. But the reality is these improvements are not increasing the fair market value of your home. They often decrease it. So if we look at the example here, a physician recommends daily swimming for an individual suffering from arthritis. A swimming pool costing $30,000 is installed. The fair market value of the home rises by 5. $25,000 may be deducted as a medical expense plus the ongoing pool maintenance. Now, I will share with you, when these numbers get higher, they may raise an eyebrow down at Internal Revenue. I had one case where the IRS agent did visit the home of an individual who had a therapeutic pool. The IRS did disallow part of the deduction because a tiki bar is not part of one's rehabilitation service. This is not uncommon. Think of someone with a physical disability. You're involved in an automobile accident. Not all disabilities occur at birth. You're involved in an automobile accident. and unfortunately become paralyzed. You have to change the entire nature of your home. So expenditures that you incur to remove structural barriers in the home of an individual with physical limitations are deductible in full, 100% as a medical expense. But it's not really full. You would add this with all of your other unreimbursed medical expenses and then subtract 7.5% of AGI. The cost of operating, maintaining are deductible as long as the medical reason for the capital expenditure exists. And yes, I do see one question up here from Stuart. I have seen this deducted on a second home as well, a vacation home, without any issue. But it's hard to find substantiation for that. And when I see questions regarding fair market value, often you can ask your local realtor for some competitive comparability statement, and that may help out. So if you look at some of these examples here, okay, cost of constructing entrance ramps, widening doorways, hallways, lowering kitchen cabinets, adding railings. Now the IRS takes the position that these are all fully deductible because they don't add a penny in value to your home. They do not add a penny in value to your home. And we'll talk about modifications to a vehicle. The modifications would also be a valid medical expense. Not the entire cost of the vehicle, but the modifications in and of themselves. Other qualifying medical expenses. Prescribed drugs, over-the-counter insulin, medicinal syringes, dental expenses. Cost of psychological and psychiatric services. Premiums for Part B of Medicare, Part D as well. Cost of guide animals, smoking cessation programs, mask, hand sanitizers, sanitizing wipes, all as a result of COVID. Special food diets, I will share with you, almost impossible to deduct. As a rule, they're going to give you the premium you pay over and above normal food. And they often refer to celiac disease in the revenue rulings. Special schools and institutions, medical conferences and seminars. We can spend hours on this in another seminar. So here's the part that is critical to us. In your traditional financial plan, you're not really concerned about public benefits and the role of our government. But in a special needs plan, you cannot ignore this at all. This is a critical component of any special needs plan. So why must public benefits be considered? And we all know this to be true. I know quite a few of you have children with disabilities. We know that the cost of lifetime care for a person having a disability can prove astronomical. We can't even find software yet that can really pinpoint a dollar amount. Few families have the resources to provide for children with disabilities fully through private means. I mean, first one to admit, I've been out of pocket some years over $40,000 in medical expenses. That's how it goes. It is essential for most families to create a plan assuring eligibility for governmental benefits to assist in the care of a child with a disability. Okay, if you did enroll in HS 377, Leslie Mahalik would talk about this. When you look at disability-related public benefits, resource dependent, and this is a critical benefit for our families. SSI, Medicaid, medical assistance, Medicaid waiver programs, and here's where the states differ dramatically. Others, food stamps, Section 8 housing, etc. Not resource dependent. SSDI, Social Security retirement, Medicare. So how do we qualify for these resource dependent programs? And I know a lot of people are incredibly proud. They do not want to rely on the government for anything. But as I've counseled people, what happens in the event your spouse pass away? Do you want your brother, your sister, your brother-in-law to go through this process? Initiate it while everyone is alive if you can. So when you look at resource-dependent programs, They're available only if individuals meet prescribed income and asset requirements, SSI, Medicaid. If you have too much income or you own too much property, eligibility is at risk, of course. Now, SSDI is a program based on what? Well, it's based on your prior work experience as a result. There are exceptions, as one person alludes to in the Q&A, disabled adult child. So SSI is critical for us. It is really critical. And Joellen alluded to it earlier. Supplemental security income pays monthly benefits to people with limited resources, limited income, who are disabled, blind, or age 65 or older. Blind or disabled children, as well as adults, are potentially entitled to SSI benefits. Now, qualifying for SSI in the majority of states, not a significant majority, would automatically qualify you for Medicaid. And Medicaid's key because it pays for hospital stays, doctor bills, prescription drugs, other health-related costs. Now, with Social Security benefits, they're typically based on your work history or a spouse's work history. SSI is not based on any prior work history for you or your family. Now, when we look at SSI and SSDI, they have a similar definition of what constitutes being disabled. But there's a tweak of a difference based on age. When you look at an individual who is 18 years of age and older, according to the Social Security Administration, disability means an individual has a medically determinable physical or mental impairment which results in the inability to do any substantial gainful activity. In English, that means work, and can be expected to result in death, or has lasted or can be expected to last for a continuous period of not less than 12 months. So you're totally and permanently disabled, you're unable to be gainfully employed, and the disability will last at the very least 12 months. Now, if you're under the age of 18, the definition is nearly identical other than what is in bold print. See, when you're under the age of 18, we look at marked and limited functionality. So we replace that substantial gainful activity. Now, how do we go about receiving SSI? Well, the resource limit in order for you to qualify is $2,000. You have to have less than $2,000 in countable resources, $3,000 for couples. Now, if you look at this here, not everything is deemed to be a countable resource. Certain resources, assets are disregarded. A personal residence, one vehicle, burial spaces. Now, burial funds would be allowed, but they're capped at $1,500. Funds in an ABLE account, funds in special needs trust, and more. If you look at this, the maximum benefit that you can receive as a single individual in 2025 is $967. If you are married and both of you are disabled, you would think you'd get twice that. The benefit for a married couple where both parties are disabled is 150% of that $967. Now, when you look at this, you're thinking countable resources below $2,000 for a single applicant, $3,000 for a married couple where both are disabled. Or if you're under the age of 18, they look at the assets of your parents, and they would need to be below $3,000 for you to qualify. They haven't changed these rules in decades. There was talk a couple of years ago of changing the 2 to 10, the 3 to 20. Has not happened yet. Also, when you look at these benefits, they are quickly eroded. If you have unearned income exceeding $20, you're going to lose part of that benefit. If you have unearned income exceeding $20 and earned income exceeding $65 or $85 in total, you're going to lose part of that benefit. So the bottom line, if you have other sources of income that approximate these benefits, you're probably going to lose most of that benefit. When you are under the age of 18, and a lot of you are familiar with this, there are deeming rules. You're under 18, you're living at home. Social Security looks at your parents' countable income and resources. The key really is to position yourself as being indigent by age 18 and apply, since the deeming rules are no longer in question. Now, SSDI. SSDI is key, and I know some of you mentioned the Disabled Adult Child Benefit, and if you enroll in our curriculum, we spend a lot of time on that. But if you look at the definition of disability, very, very similar to SSI. The disabling condition has lasted or is expected to last at least 12 months, is expected to result in death, and prevents substantial gainful activity. Now, substantial gainful activity is a cliff. If you exceed that, you are no longer deemed disabled. The dollar amount in 2025 is $1,620 if you're not blind. If you are visually impaired, it's $2,700. If you're making more than that in a month, and that is not by any stretch of the imagination rich. So if you're making a little bit under $20,000 a year, you are not disabled. And I think we all know when you make $20,000 a year in the US, you are living like royalty. Of course you're not. Receiving SSDI and going through this with friends right now, oh, it's not an easy process. Tons and tons of documentation regarding the disability. It's critical that you have all this paperwork. So when you look at SSDI, in order to collect it as a very general rule, you needed to have worked. And typically it's 5 of the last 10 years prior to the onset of disability. When you look at the key criteria here, you must be under full retirement age. Well, what's full retirement age? 67. Must not be receiving substantial income through employment, more than 1620. Must be a U.S. citizen or have lawful residency. Now, the DAC benefit is critical. There's a parlay between SSI and the Disabled Adult Child Benefit. The Disabled Adult Child Benefit, in a broad-based nutshell, allows your child who is currently receiving SSI to apply for and receive up to 50% of the parent's Social Security benefit when that parent retires or becomes disabled. The benefit to the child may be increased to 75% if the parent were to die. Now, there's a lot more to it than that, but it's a significant parlay from SSI to SSDI and may end up doubling the child's benefit. And if you're receiving SSDI, there's no countable resource rule. Medicaid. As we've indicated, an application for SSI is typically an application for Medicaid. Medicaid, however, is administered differently in every single state. So it is available to individuals who are eligible for SSI and for certain other individuals with limited income and resources, for poor people. If an individual is eligible for both Medicaid and Medicare, Medicaid becomes the secondary insurance. Now, we all know for our children who are receiving SSI, Medicaid is typically their primary insurer. With Medicaid, it does pay for catastrophic long-term care facilities. Medicaid pays for that, Medicare does not. Regarding Medicare, now Medicare is going to become available if you are on SSDI for at least 24 months plus a 5-month application period. Medicare is available for those who are 65 years of age or older and individuals of any age suffering from permanent kidney failure. Individuals who receive SSDI or that Disabled Adult Child Benefit for 24 consecutive months become eligible for Medicare. And again, Medicare becomes your primary insurance, Medicaid your secondary. And Medicare has those four parts. A being hospitalization, B your physician services, C Medicare Advantage, and D the prescription plan. Joellen, you are back up and I'll try to answer some of these tax related questions.
All right, let me get back to my notes here. Okay, so and by the way, phenomenal questions coming through the chat. I love how everyone is so engaged and again, really kind of hitting the nail on the head in terms of what are critical issues. So keep them coming. So next we're going to talk about estate planning and special needs trusts. So what are most critical estate planning considerations when there is the potential that any beneficiary of any age is going to inherit money? And it's important that this comes right after public benefits, the public benefits section that Tom just went through, because that is really one of the key considerations when when there is the potentiality for someone with a significant disability to inherit money. And that is because unanticipated inheritance can overnight jeopardize that disabled individual's financial eligibility for needs-based public benefits, like Tom just described, SSI and Medicaid, for example, which are probably the two most common benefits that individuals with disability of any age are utilizing. I can't tell you the number of people. I did quite a bit of estate planning in my prior life as well. And I can't tell you the number of well-intentioned loved ones, grandparents, aunts, uncles, etc., who named their loved one with a disability as the beneficiary of their IRA or a life insurance policy, or even just a small token amount to their grandchild who has the autism diagnosis, leaving them $5,000, $10,000. At the time of death or when that asset is transferred into that beneficiary's name, it can immediately place them over the limits and they could lose their eligibility within, the next month for what are really, really critical benefits. Now, there are things that can be done. In fact, November 5th, that's one of the things we're going to be talking about is how do you correct mistakes in the estate plan after the fact. And there are things that can be done. We're going to talk about that, what you can do. But it's better, in my opinion, it's better to kind of head these problems off at the pass and plan appropriately for them up front. So you want to always have an individual's potential public benefits eligibility in mind. And why I say potential benefits is because there are situations where someone might be living and working independently, not availing themselves of any public benefits, but has a disability or gets a diagnosis that is likely to result in their having a disability at some point. Think of getting an early onset Parkinson's diagnosis. I had clients who were still working through those symptoms for quite a while, but at some point we knew the train was coming down the tracks and we weren't going to be able to stop it. They were going to need some sort of assistance. So we started planning proactively. If they had a loved one who might be leaving them money, let's set things up so that just in case this person needs public benefits in the future, we have flexibility built into their estate plan to make sure that they're protected, the money is protected for their use no matter what. And again, the only time you would ever, if you know that a beneficiary has some sort of disability, the only time you would ever consider distributing assets outright to them is I didn't say this in the slide, but if you know that they have the capacity, obviously, to manage that money and are not going to be taken advantage of. But two, you know for sure that they are going to never have the need to qualify for public benefits. It's very rare. Other options, other things you shouldn't do before we go on to what you should do. Um, a lot of folks will say, well, listen, I have an easy solution. I don't need to have a fancy trust or spend thousands of dollars on legal fees. I just will disinherit my, child with a disability, my adult child. However, if there is money out there that can potentially be set aside for that person, you have to remember that we live, especially right now, we are living in some uncertain times. There are lots of changes coming in terms of policy. And we don't know what the future is going to hold. We don't know what state budgets are going to be able to accommodate. Public benefits could be reduced or even, God forbid, eliminated in the future. So think about that before your client just says, hey, I'm just going to write them out of the will because I don't want to mess up their situation or I'm afraid I'm going to do it wrong. Another mistake, something that works, up front and is a simple solution, but can have bad secondary effects, is leaving property to another family member with the understanding, that handshake agreement that they are going to use the property for the benefit of that, family member or beneficiary with special needs. Um, I could walk you through the parade of horribles. Aging parents leave money to the one sibling, the sibling who is not disabled, with the promise that that sibling will support their, 40-year-old brother for the rest of his life. However, that individual who got the inheritance, the healthy child, fully functioning child, gets divorced. That child dies themselves prematurely and didn't account for what was going to happen to that money in their own will. So now it goes to their children who may not want to take care of their aunt or uncle. They are in a horrible car crash and get sued. It is an asset that they have that's unprotected potentially. They could waste it, they could spend it. You want to trust the people who are in your life, but trust but verify. Be cautious. Put what legal protections in that you can. And the third option that you probably shouldn't consider is establishing a discretionary support trust for the beneficiary with special needs. Think of this as your standard trust that you might see in a will for anyone, regardless of disability. It's for their health, education, maintenance, and support at the discretion of the trustee. The trustee can distribute money, etc. That type of support trust, even though it might offer certain asset protection, in the traditional sense, is not necessarily going to keep them qualified for public benefits. So what estate planning options should be considered? And this is where we talk about special needs trusts. So the silver bullet that pretty much should work in any situation is establishing a third-party special needs trust for the beneficiary. I say special needs child, but really for the beneficiary with special needs. The way that this works is you have your last will and testament can direct that any assets that are being distributed to a disabled beneficiary be placed into a third-party supplemental needs trust or third-party special needs trust. You can use either term, that is established by the testator. We'll talk a little bit later about exactly what, next we'll talk about what it means to be a special needs trust. But again, the whole reason behind this is not just to protect the assets, because there are many different types of trusts that can give asset protection. This is a trust that is specifically, literally, by statute, in many cases, designed to protect public benefits eligibility. So what is a special needs trust? A special needs trust is a asset management device that is used to protect the assets of individuals who are either already receiving needs-based public benefits or who anticipate long-term disability in the future and might need public benefits. That's my early onset, Alzheimer's, or early onset Parkinson's disease example. Understand that certain disability criteria must be met at the time the trust is created. Discretionary distributions is what is really the goal for the special needs trust. And when we say discretionary distributions, we mean what are those extra quality of life items and services not provided for by government benefits? It is meant to supplement, not supplant public benefits. This is language, depending on whether it is a third-party trust, we're also going to talk about first-party special needs trusts. This language becomes very, very critical and is required by federal statute. Now, before I get into the detail on special needs trust, I want to talk about funding. And Tom, I didn't mention this to you, but I saw this quote is from Candace Pollock, who is actually a former mentor of mine.
Really?
Phenomenal attorney from Ohio. Yeah, phenomenal attorney, lovely human being. And so the quote from their publication is, "It is often necessary to fund a special needs trust with more than what may be considered a fair share. However, sometimes there is nothing more unfair than the equal treatment of unequals. In the case of a family that has a child requiring a resource for lifetime assistance, equality of treatment may be impossible." And what this is a quote that is meant to be thought-provoking, in that these are not easy decisions to make when deciding how to fund a trust or provide for someone with a disability after life, especially in families where you have multiple children, some of whom have gone to college and had children and have a family and have a career, etc., and may have not gotten maybe their quote unquote fair share of attention from their parents, because their parents were understandably had to be focused on the other child or another individual with special needs or disability. So it's a difficult question to answer. So it's something that has to be addressed with sensitivity, and there is no right or wrong answer to that. All right, so special needs trusts. So there's two primary types of special needs trusts. First, you have a first party special needs trust. This is not, I'm jumping around a little bit here, but this is not what I just talked about, what you do in the estate plan. The first party special needs trust is actually the fix. That's the Band-Aid for when the estate plan was maybe not handled correctly. So a first party special needs trust, how it is critically different from a third party trust, it is established and funded using the disabled individual's own assets, and it must be done before the age of 65. It can be established by, as statutorily required, by either a parent, a guardian, or the disabled individual, him or herself, if they have capacity to create their own trust. And the most critical element of this is that there is a state payback provision required. What that means is that if someone has a first party special needs trust and they got that so that they could, for example, receive Medicaid benefits because they have really complex medical needs, medical expenses, et cetera, maybe need to live in a facility. When they pass away, if there is anything left in that trust at the time of their death, it goes back to the state or states where they were receiving benefits to pay them back as much as possible. Now, there could be situations where someone has a first party special needs trust and they end up not, it's rare, but end up not using any state funded services. In that case, you also, after, in my case, I live in New Jersey, the state of New Jersey is the number one beneficiary of that trust at the death of the original, but maybe it's their siblings are named as the secondary beneficiaries or their parents or whomever. Where that first party special needs trust get used is when there is someone has a disability and already has certain assets in their name and has a sudden need for public benefits. In that case, this allows them to set aside the assets that they already have so that they can still use them to supplement their quality of life. Okay. Or it's in these inadvertent situations. Someone unexpectedly comes into money, maybe, or a lot of times they win a legal settlement. And those settlement proceeds, in and of themselves, even though they're supposed to be there to compensate them for the personal injury that occurred that caused the disability, those funds can immediately be tucked away into a first party special needs trust by the individual, and they keep receiving all of the same benefits that they always have. Now, this is different from a third party special needs trust or supplemental needs trust in that the third party trust is established by a different individual, not the disabled individual themselves, but it's established for the benefit of that individual, and it is funded with someone else's money. Okay, it is not funded with the assets owned by that disabled individual. One fun fact about third party special needs trust, parents of a adult disabled child, for example, can create that third party special needs trust. It can be a bucket that is immediately opened. It is a standalone trust that immediately goes into effect. Other family members can all in their own will say, I direct for my, $40,000 to go to this third party special needs trust for the benefit of X beneficiary established on this date by this person. It can be a bucket that can hold money from many different individuals for, again, to supplement the quality of life and the care needs, et cetera, of that individual with disabilities. Best part about a third party special needs trust, there is no state payback provision. So when we talk about advising on, how you're covering someone's cost of care, say you have a client who has both the first party special needs trust and a third party special needs trust, and say each one has $100,000. You're going to want to spend the money in that first party special needs trust first and deplete that first before you start tapping into the funds that are held in the third party special needs trust. Why? Because you don't want there to be any money left to go to the state, if it can be appropriately used for the individual. You don't spend it for, frivolous things, just for that reason. But there are strategies that can be employed here, again, to maximize kind of the long-term outcome for the entire family, frankly. And again, whoever's the grantor, the creator, the funder of that third-party special needs trust, they can name remainder beneficiaries who can inherit any assets remaining in at the original beneficiary's death. And this is where I see, Tom, we are starting to get a little bit
Yes.
behind on our time. So community pooled trust, I think we'll actually skip over this, except to say that in situations where someone has a trust that is not large enough to be managed by an outside trustee, there are nonprofit organizations that will pool small amounts of money together for disabled beneficiaries. Okay, next slide,
Sure.
and we'll switch to Tom.
Okay, thank you. I mean, the very, very basic review here. So when you have a first party self-settled special needs trust, first party self-settled, self-funded special needs trust, it is funded with the beneficiary's assets, typically maybe a personal injury award or maybe some bad estate planning. Since the trust is being funded with the beneficiary's assets, more often than not, they are what they call grantor trust. Now, grantor trust means the incidence or burden of taxation will fall on the beneficiary. The trust files an informational return and provides a letter to that beneficiary. Well, that may not be the end of the world. As the income flows through to the beneficiary on a K-1, if they're not taking distributions, it does not adversely impact SSI. Now, there is a significant downside to this strategy. What is it? The kiddie tax. That's beyond the scope of this. So with a first party special needs trust that is treated as a grantor trust, there may be kiddie tax issues if the individual having a disability is under the age of 19. If it's a complex trust, the burden of taxation will lie with the actual trust. And sometimes we use a modified conduit. Now, when you have a third party special needs trust, they are typically set up as grantor trust. The parties doing the funding are not the beneficiary having a disability, and they typically report the income, deductions, and credits on their own return as a grantor trust. One area we recommend is why not set up a qualified disability trust? Now, the beauty of that qualified disability trust, it's a complex trust, relieving all of the income within the body of the trust to be taxed at these confiscatory trust rates, but you get a $5,100 personal exemption. And that will eat up quite a bit of taxable income. So that may not be a bad strategy. Planning tip, you've got to work with a financial advisor that knows how to minimize the tax implications of these trusts. You really do. It's not a guessing game. And the beauty for all of us is we know that 99.9% of these have not yet been funded. So in the next 10, 20 years, as we as parents pass away and move on to that greener pasture, that's going to be a bonanza in business for a lot of CPAs and financial planners. The ABLE Act, we have one or two slides here. Now, the ABLE Act may be the best type of tool you can use, this coupled with the pooled trust, because the out-of-pocket cost is close to nothing. This is Section 529 Cap A. Now, initially, it was going to be similar to a 529 plan, but it's really evolved quite a bit. It currently enables individuals who become disabled prior to the age of 26 to save up to $100,000 in an ABLE account and avoid jeopardizing their SSI. If you're using it to accumulate beyond $100,000, it then becomes a countable resource and works against your SSI qualification. But Medicaid still exists. Now that 26 becomes less than 46 or under 46 as of next year. We all know that within the body of the ABLE account, that all of your contributions and that growth within the account are really tax-free until withdrawals are being made. If the withdrawals for a qualified disability expense, housing, transportation, employment training, financial planning and legal fees, health, prevention, and wellness, it's not going to be a taxable distribution. But if you're using it, let's say, for a vacation, it may be deemed a taxable distribution, not only for income tax, but because the beneficiary is under the age of 59 and a half, 10% penalty on the taxable component. The maximum amount that you can contribute in 2025, and you're only allowed one ABLE account per beneficiary, is $19,000. Now, if the beneficiary is working, they can also contribute the lesser of what they earn or the federal poverty level for a one-person household for the prior year. So this provision was made permanent by the One Big Beautiful Bill Act. But again, there's a caveat here. If your son or daughter is working and is eligible for that retirement plan at work, the additional bonus contribution does not apply. Joellen?
Okay. We did pretty good staying on track time-wise throughout
We
this.
did.
I'm going to breeze through our final topic, which is guardianship and other alternatives, and then Tom will spend a minute or two talking to you about the ChSNC program, and we'll wrap things up. Again, keep the questions coming into the chat for the Q&A, because I feel like this has eliminated the need for us to do a Q&A at the end of the presentation. This has been this ongoing thing, and for those of you who maybe haven't been following along, you may want to jump into the Q&A. I think the answered questions should still be in there, and there were a lot of really, really great questions. So what is guardianship and when is it needed? So guardianship, and let me say at the outset, the term guardianship, that may not be the exact term that is used in your state. There are different terms, conservator and others that are used across the country. So what it is, so you understand, regardless of what it's called, it is a legal protective arrangement where a court appoints someone, a guardian, to make decisions for an individual who is unable to do so on their own due to disability or incapacity, mental incapacity. So you typically have full guardianship versus limited guardianship. What does full guardianship mean? So this is the broadest authority you can get. This completely removes that individual's right to make key life decisions. And it should only be used when that person has significant cognitive or functional impairments. It is acknowledged that it can be overly restrictive and it reduces autonomy. And, 10 years ago, 5 years ago, 10 years ago, it used to be that the standard advice you would give to someone is second that person turns 18, or no matter what their form of, if they have a diagnosis, you're going to need to get guardianship, get guardianship, get guardianship. Trends that have been happening across the country is more and more within the judicial community, they are leaning away from just kind of rubber stamping guardianship applications if a person has demonstrated the lack of capacity, mental capacity, and it is because it is viewed as taking away all of their legal rights. So there should be a very, very high standard, and other alternatives should be considered if at all possible. So then, instead of a full guardianship, you can look at a limited guardianship. So this is where, again, these situations are never black and white. You might have someone who is highly physically impaired, but still has mental capacity, or maybe can't understand math, to balance their own checkbook, or is vulnerable to being exploited, and so thus should not have control over their own money. But they can make their own medical decisions. They can decide if they want to go to the doctor. They can decide where they want to live, things like that. So a limited guardianship is going to be specifically tailored to preserve as much independence as possible. And it is based very specifically on the individual and usually requires a lot of nuanced planning on the part of the legal advocates. Another term which has come into greater popularity in recent years, again, because of this acknowledgement of wanting to preserve the rights of individuals who are living with disabilities, is the concept of supported decision making. So this is a less restrictive alternative to guardianship, and it is where the individual with disability retains all legal decision-making rights, financial, medical, etc. However, there is a organized plan in place for them to select trusted supporters, family, friends, professionals, etc., who can help them work through options that they are considering for housing, medical, etc., can help assist them in making decisions and sorting through those options, and help them communicate, advocate for them, and help them communicate the choices that they have made. In many states, this is now still going through the court system. Someone has typically filed a guardianship petition to have the person declared incapacitated. And through the process of evaluating the medical opinions and talking with the alleged incapacitated individual, talking to family members, etc., there's like a negotiated process where they end up where it is a formal alternative to guardianship, but it is, established that this person will consult with XYZ, or these people will assist them in making decisions. In such a case, if this person has legal capacity, no matter what, you want to make sure that they execute powers of attorney to authorize an agent to act on their behalf if needed, if they were to ever lose that. Because if you don't have a power of attorney, this is true for all of us on this call or anyone out there, if you have decision-making capacity, make sure you execute a power of attorney while you have the ability to do so. Otherwise, something unexpected happens to you, it's going to go into the court system potentially, and your family may have to seek guardianship for you. All right. Next, quickly, guardianship legal process. It varies by state and jurisdiction. It must be granted by a court after an evaluation of the person's abilities. There is, generally speaking, does vary depending on the jurisdiction, but there is always some sort of medical or psychological assessment. It is not just the word of the person who is filing the petition. They have to have medical experts who back them up. Notice is typically given to family members who have the right to object, and notice is given to the alleged incapacitated person themselves so that they have the right to fight against it if they feel their rights are being taken away. It can always be contested. Sometimes circumstances change and someone's life condition changes and they regain capacity. And it can be revisited periodically. And again, as a reminder, this is often considered by parents when the child turns 18 because after that age, they are no longer considered their natural guardian. Last slide, substantive slide, and then Tom is going to tell us a little bit about the Chartered Special Needs Consultant division designation. So again, takeaway, what are the most critical resources for advisors? You need to, if you're an advisor here on this call today, you need to build your client's team. And I would say you need to build this, slate of professionals who you know and trust even before clients like this come to you. You need to research who are good family advocates in your community. Who is going to be potentially a guardian for your client? Do they have an agent under power of attorney? You're going to need to talk to special needs planning and special needs education attorneys in your local community. If you're looking for a special needs planning attorney, there are two organizations, membership organizations that are actually three that you would want to look to. One is the Special Needs Alliance, which is a group of attorneys. There's one in every single state who have been invited to join this very prestigious organization because they have a demonstrated expertise in special needs. The Academy for Special Needs Planners, attorneys are members of that. And then NALA, the National Association for Elder Law Attorneys. Even though it says elder law attorneys, a lot of those folks also have special needs expertise. You want to think about trustees, trust protectors, your CPA like Tom. Tom is very special. There is not a lot of CPAs out there who understand these rules. So it's like finding a needle in a haystack. And then obviously the financial services professional. These are all the people who collectively should be on that individual's team. So that concludes the formal education part. Tom, if you want to quickly tell them about the ChSNC program, and then we'll wrap things up.
Thank you. Regarding our Chartered Special Needs Consultant Program, based on the number of questions, I cannot type that fast to answer all of these questions, but a lot of your questions will be answered, I believe, if you enroll next month in the advanced topical courses. So they will address a lot of these answers. We just did a broad-based overview today. But for those who are really more interested in learning about this, and quite a few of you have already earned the Chartered Special Needs Consultant designation, I liken this to a concentration within an MBA program. It's a 3-course designation. And we're looking for people that are already CFPs, MBAs, bachelor's degrees. We're looking for people that are already chartered financial consultants who have a basic understanding and want to add that level of recognition to their practice. So when you look at the Chartered Special Needs Consultant Program, 3 courses, one is on disabilities. Just a broad-based course on understanding what is meant by a disability today. Second course is the nuts and bolts, HS 376, and that course will focus on public benefits, estate planning, trust administration, some basic issues regarding income tax, guardianship. And that's the most challenging of the courses for those who are not actively involved in the practice. Third course, very unique to the college, is a webinar-based course. And it's being delivered over a 4-week period. And it's pretty cool because you get a chance to see sometimes Joellen, you'll see Dr. Mary Hauser, Leslie Mahalik, a special needs lawyer. So it's not an overwhelming program, but I see some questions. It's a program for those who are parents, who are financial advisors. It's a program for those who already have other credentials. So it's not a standalone designation in and of itself. So I want you to think about this. I'm sure a lot of it does count for CE. If you haven't been involved in the profession, you'll easily skate through the first course, but the second and third one, the people that do the best are those who practice in this area or have a child and they have learned via baptism by fire. So I welcome you all to join. We have about 1,000 designees over the last 10, 15 years. So it's a pretty small, exclusive group. But thank you all for attending today. Joelle and I really do appreciate it.
Yeah, we're going to wrap things up. Thanks, Tom. That was great. So a poll should have just popped up on your screen. Please take 2 seconds to answer those questions. We absolutely review the results from any of our post-event surveys, educational events, I should say. And please give us your feedback. We want to know what we can do better. All the time. So if you are interested in becoming a chartered special needs consultant, please feel free to scan that QR code. And we have a promo code there as well to save you 15%. That's your reward for sitting through an hour and a half with us today. I also want to tell you about a program we have called Resilient Finances, Thriving with Disability. If you want to take a quick snapshot of that QR code, this is a consumer literacy program that the center developed a year or two ago with funding from the Christopher Reeve Foundation. It is designed for individuals facing disability or caregivers, and it is free financial literacy online education. Thank you so much for attending. Thank you so much for being engaged and for asking all the fantastic questions that you did. And hopefully we'll see you on November 5th for the advanced sessions. Thanks.
Expand your opportunities at theamericancollege.edu.